Thank you, Acting Speaker, and I rise to speak on the Justice Legislation Amendment Trial by Judge Alone and Other Matters Bill of 2022. Now, this is a bill that proposes to extend by 12 months, while the pandemic orders are still in place, the capacity for an indictable offence to be heard by Judge Alone, and for special hearings relating to mental health impairment to be heard by Judge Alone. And a couple of other things, such as to extend by 12 months the default requirement for an adult in custody to attend the magistrate's court and have a contested hearing or committal hearing by audio-visual, and also for youth under certain circumstances to be able to also use audio or audio-visual links for safety reasons. There is another provision that I will expand on as well in the bill, which is relating to an Occupational Health and Safety Act. But as far as trial by Judge Alone, in principle we do not oppose this 12-month extension, but very much as long as it is tied to the pandemic orders, and that it should be a temporary provision, as mentioned just then by the member for Carrum, that temporary is the issue here. This is not a green light to do away with juries, because it's so important to our justice system to be a feature of it being fair is for the right to a person to have a trial by jury, which I think is a long-held value of our system. But as a result of the COVID period, we see in Victoria, the state which has the longest lockdown and the harshest restrictions, certainly a very large backlog in the court system which does need to be dealt with. And so this measure does go somewhat towards doing that, but it isn't probably doing enough. And I would suggest that when you look at the productivity report, a report that is a government services report that was produced a couple of months ago, that actually highlights that the Magistrates Court, for example, in Victoria is so far behind. Compared with all the other courts in Australia, Victoria, like we do with so many other horrible accolades that we now hold, have the worst backlog of any state. So if you look at the Magistrates Court, we have a backlog of over 12 months, 19.3, I think it was, cases will have a over 12-month wait, as against in New South Wales, which I think was about 5%. So these are not things we should be proud of. Like our hospital waiting lists, we have a very long waiting list for people, and we've got other things we're hearing about, like the worst funded health system in any state of this nation. So the courts is no different. It's an absolute failure on this government, and it's shocking to be seeing people who are denied justice. Now, I spoke to a lawyer from my electorate just this morning who wanted me to highlight that this is a problem right out into the regions, and in South West Coast we're having lots of issues with this backlog because it affects people in our region. Now, I do need to state that the magistrate of Warrnambool, Mark Stratman, has made comment as well that it's causing a lot of problems. But I do want to point out that this is not the magistrates that are causing these issues. They are doing everything in their power. It is resources that the government are not putting forward to be able to deal with this issue that is the problem, and that's been stated by Mark in his comments and other visiting magistrates to the Warrnambool Court Circuit of Portland and Hamilton. And so this local lawyer talked to me this morning about cases being adjourned off for up to 7 months. Just in the last 2 weeks, he said cases in March were being adjourned off till October. Now, justice delayed is justice denied. But, he actually really brought it home when he talked about the domestic violence cases where you're living in a small town like Portland, Hayward, Warrnambool, Hawkesdale, and you've got a domestic violence situation where your partner who is violent to you has been bailed. The case can't be heard for up to 12 months, 7 months to 12 months, and that's only when it starts. It might be 12 months before it's finished. So you're living in fear. And as he mentioned, it's often the case that these people are very clever to avoid their bail conditions being breached. They often have sociopath behaviours, of intimidating the women, and that's a really concerning situation. So I'm really concerned to hear that from that local lawyer that this is happening in our part of the world, because that's something that justice delayed is justice denied. But I think the government can do a lot more. These little changes really don't go far enough. And when you look at the VCAT system that was set up, and it was set up to help people who haven't got lots of money to help with disputes such as neighbours' disputes or tenancy problems for the landlord or for the tenant who's renting. And there's such a backlog that people cannot even get within a 2-year period their disputes settled, and we're seeing that in South-West Victoria constantly. But also we're seeing, with my shadow minister hat on for Consumer Affairs, last year there was over 3,000 reports to Consumer Affairs about lemon cars. And it's so important that the government looks at ways to make VCAT, for example, more accessible, or to develop other systems that help people get affordable, accessible and timely alternatives to dispute resolution. People who have bought second-hand cars from 10, 20, 30,000 or new cars even are not getting the justice they deserve. And it's not as if these people, and that's why VCAT was designed, have lots of money that they can put that car aside that was going to get them to and from work and say, oh, well, I can't get a resolution through VCAT, Consumer Affairs aren't able to do any more than that. Why isn't the government helping? Because I don't have 10, 20, 30,000 to go out and replace that car. That's what consumer laws are supposed to do. So the government has the opportunity to do far more than they're currently doing to help our community from this situation. Now, I will get to the last point that's very concerning in this bill, and I will note that this is not a justice matter. It's been thrown in this bill as it feels like an afterthought, which we're seeing so many times from this government. It's actually an Occupational Health and Safety Act of 2004 that it affects, and in this bill it extends this provision in the pandemic orders by 6 months, and it means that a pandemic order or a COVID-related public health direction can be deemed an immediate risk to public health. So what this means is the WorkSafe inspectors will be given extraordinary powers under the Occupational Health and Safety Act, and under Section 112 of the OH&S Act, they can issue a prohibition notice and effectively shut down a workplace or a business from a very minor incident. So it doesn't have any graduation process or any proportionality. A minor breach will be deemed as a risk, immediate risk to public health. So to play that out so you can understand what that means, I walked into a service station the other day and there was a worker with the mask under his nose. Now, I'm sure he didn't mean any harm, and from my perspective as a consumer, there was a perspex between him and I don't have to wear a mask under these laws, which is, from an infection control perspective, doesn't actually make any logical sense to me. But if an WorkSafe inspector had have walked into that workplace, that minor breach of not wearing the mask properly could have effectively shut down that workplace. Now, the government says, oh, well, I'm sure the work inspectors won't do that. Now, we hope that people won't do that. But we've already been hearing from people where businesses have been shut down through the last 2 years of the pandemic when they've been doing their best to abide by the laws and have had the QR code up and have checked all their staff for vaccination certificates, but actually haven't collected the vaccination certificates and had them there to present to the inspector, because who knew what we were allowed to do from a privacy perspective? It's been very, very hard for business. So to have this provision in the bill, which, in the words of the Housing Association, Industry Association, who we spoke to about this, who I might add didn't know about it, said in the absence of evidence that further extension is necessary, there is no case for this section to be extended for another 6 months, and the clause should be removed from the bill. So we will be taking action in that other place to try and have that removed. Businesses have had enough uncertainty. Businesses have had enough confusion. We need to recover this state from this pandemic. We need to rebuild, and business will play a really big part in that. Let's get behind business. They've had enough of the uncertainty. We need to support them. The government won't do that.